This case did not survive because it was hidden. It survived because it was documented. For years, complaints were filed, statements were recorded, investigations were opened. Paper existed, dates existed, signatures existed. The system knew, and the record shows it. The question then is not how the truth was uncovered, it's how it was absorbed. In most criminal cases, documentation triggers escalation. Prosecutors act, courts respond, procedures tighten. Here, the opposite happened. As records accumulated, consequences diminished. This is why focusing on personalities misses the point. Jeffrey Epstein is not the mystery. He is the constant. The variable is the system around him, the legal steps taken, the agreements signed, the decisions formalized in writing. None of this happened in the shadows. It happened inside institutions designed to stop exactly this kind of crime. What followed was not denial, but management. Not erasure, but containment. The case was processed in a way that allowed it to remain legally intact while socially neutralized. Years later, when documents resurface and public attention spikes, it feels like revelation. But nothing new was created. Nothing secret was discovered. What shocks people is not what the documents say. It's the realization that they were always there. This is a story about how a crime can survive disclosure, when procedure replaces accountability, and record-keeping becomes a form of protection. The public narrative often suggests that this case emerged suddenly, as if it appeared fully formed years later through court releases or media attention. The documents tell a different story. The first formal records appear long before any national scrutiny. By the late 1990s and early 2000s, complaints had already entered official channels. Police reports were filed, statements were taken, names, dates, and locations were written down. This was not rumor, it was paperwork. What matters here is not the volume of early records, but their nature. These were not anonymous tips or informal warnings. They were structured complaints that followed established procedures, the same procedures that, in most cases, initiate escalation. In criminal systems, documentation is supposed to create momentum. A report leads to an inquiry. An inquiry leads to prosecutorial review. The process tightens as information accumulates. In this case, the opposite pattern appears. As early records formed, the case did not disappear. It stabilized. The presence of documentation did not trigger urgency. Instead, it produced a kind of administrative stillness. The system acknowledged the information without converting it into action at scale. This distinction is crucial. Silence can be explained by ignorance. Inaction in the presence of records cannot. By the time broader investigations began, the file was no longer empty. It already contained corroborating accounts, consistent descriptions, and repeated references to the same individual. The system was not discovering a problem. It was revisiting one it had already cataloged. Jeffrey Epstein enters the record here not as a mystery figure, but as a known subject of complaint. His name appears in documents years before the case becomes publicly recognizable. This alone dismantles the idea that the truth was unavailable. What follows is a pattern visible only when time is taken seriously. Each additional record should have narrowed the space for discretion. Instead, discretion expanded. Jurisdictional boundaries slowed movement. Responsibility diffused. The existence of prior documentation became a reason not to act decisively, rather than a reason to intervene. This is how early disclosure loses its force. The system did not deny the records. It did not destroy them. It did not claim they were false. It simply allowed them to exist without consequence. When later audiences encounter these documents, they often assume they represent a breakthrough, a moment when the truth finally surfaced. In reality, these records mark the opposite moment, when the truth entered the system and failed to move it. Understanding when the first records appeared changes the entire case. It reveals that the central issue was never a lack of information. It was the choice to treat documentation as an endpoint, rather than a trigger. From that moment forward, the crime did not need to be hidden. It had already learned how to survive being written down. Crimes do not persist only because of who commits them, but because of where they are processed. In this case, the critical question is not why the system failed everywhere, but where it succeeded in neutralizing consequence. The earliest records did not vanish into obscurity. They moved through specific institutional spaces: local law enforcement, prosecutorial offices, and judicial procedures. Each space acknowledged the information. Each space touched the case. And yet, at no point did the process accelerate. This is how absorption works. At the local level, investigations followed recognizable forms. Reports were logged. Interviews were conducted. The case existed within official channels long enough to generate a paper trail, but as the process approached points of escalation, charging decisions, jurisdictional transfer, prosecutorial coordination, momentum slowed. The system did not break, it narrowed. Jurisdiction became a boundary rather than a bridge. Authority fragmented across offices that could act, but not collectively. What should have been a ladder became a maze, each institution holding a piece of the record, none carrying the weight of the whole. This fragmentation matters because legal systems are designed to escalate vertically. Local findings move upward. Patterns trigger broader review. Here, that vertical motion stalled. The crime was not pushed out of the system. It was contained within it. Jeffrey Epstein passed through these spaces not as an unknown offender, but as a known subject of inquiry. His case did not fall between institutional cracks. It sat directly inside them. What makes this absorption visible is not secrecy, but formality. Decisions were made through recognized mechanisms: discretionary charging, negotiated agreements, procedural limits. These are not errors, they are tools. And tools shape outcomes. Where courts should have expanded scrutiny, the process contracted. Where oversight mechanisms exist to detect patterns, the case remained segmented. Each institution handled its portion in isolation, producing a result that was technically valid and substantively hollow. This is the paradox of institutional absorption. The more formally a case is processed, the easier it becomes to disperse responsibility. By remaining inside the system, always documented, always procedural, the crime avoided the one condition that forces transformation: consolidated accountability. When people ask where the system failed, they often imagine a missing step or a hidden obstruction. The documents suggest something else. Every step occurred. Every form was filed. Every boundary was respected. That respect is what neutralized the case. Understanding where this happened reframes the entire narrative. The crime did not survive by escaping the system. It survived by moving through it exactly as designed, entering spaces that were capable of recording harm, but not structured to confront it collectively. Once absorbed in this way, the case no longer needed concealment. It existed everywhere it was allowed to exist, and nowhere it could not be challenged. At first glance, the question of who seems obvious. Criminal cases usually center on offenders and victims, guilt and responsibility. But in this case, focusing on individuals obscures the more revealing issue: who the process itself was designed to accommodate. Legal systems are not neutral by default. They are structured around assumptions about risk, credibility, resources, and discretion. Those assumptions determine how flexibility is distributed and who benefits from it. Here, the record shows a process that bent without breaking. Jeffrey Epstein was not treated as an anomaly within the system. He was processed through it in ways that were fully legible to those who operated. Every stage of the case followed recognizable legal pathways: negotiated outcomes, discretionary decisions, procedural containment. Nothing about this required rewriting the law. It required knowing how to use it. The key distinction is not innocence versus guilt, but standard versus exception. Most defendants encounter a system that narrows options as evidence accumulates. Here, the opposite occurred. As information increased, flexibility expanded. That flexibility is not distributed evenly. The process privileged continuity over disruption, stability over scrutiny, resolution over examination. These are values embedded in institutional design, particularly when cases threaten to become complex, expansive, or reputationally costly. The beneficiaries of such a process are not limited to a single person. They include institutions themselves. A contained case is manageable. A fragmented case is defensible. A resolved case is final. In this sense, the system was not merely protecting an individual, it was protecting its own procedural equilibrium. Accountability was shaped to fit what the system could absorb without transforming itself. This reframes the idea of protection. It was not overt favoritism, but structural accommodation, the kind that allows outcomes to appear lawful while remaining insulated from broader consequences. Importantly, this does not require conspiracy or coordination. It requires alignment. Each actor operates within accepted norms, prosecutors exercising discretion, courts honoring agreements, jurisdictions respecting boundaries. Individually, these actions appear ordinary. Collectively, they create extraordinary insulation. The process, in effect, was built to favor those who could navigate it, those whose cases could be narrowed, segmented, and resolved without triggering systemic stress. This is why the question of who cannot be reduced to a list of names. The documents do not show a system hijacked by an outsider. They show a system functioning smoothly for a particular category of subject, one whose case could be treated as administratively solvable rather than structurally threatening. When viewed this way, the outcome stops looking accidental. The process did not fail its design. It revealed it. Understanding who the process was built for clarifies why later disclosures feel destabilizing. They expose a gap between what the system records and what it confronts, between formal resolution and substantive accountability. In this case, the process worked, just not for the people who expected it to protect them. Subscribe to the channel. This is where power, history, and technology are examined without comfort. At no point did the legal system need to deny the existence of the crime. It only needed to shape how the crime could legally appear. This case demonstrates a specific mechanism of institutional control. Exposure is not eliminated, it is managed. The law provides multiple tools for this management, all legitimate in isolation, all consequential in combination. The first tool is discretion. Prosecutors are granted wide latitude in how they charge cases, what statutes they invoke, and which paths they pursue. Discretion is designed to allow flexibility. Here, it functioned as a narrowing device. The scope of potential charges was reduced, reframing the case into something smaller, more containable, and easier to resolve. Next comes negotiated resolution. Agreements are a standard feature of the legal system, meant to conserve resources and ensure predictable outcomes. In this instance, negotiation did not follow the gravity of the allegations. Instead of expanding scrutiny, it compressed it. The legal outcome addressed the minimum necessary to close the case procedurally, while leaving broader conduct outside judicial examination. This compression matters because courts respond to what is formally before them. When a case is narrowed at the charging stage, the court's role narrows with it. Another mechanism is procedural segmentation. Jurisdictions operate with defined boundaries, and coordination between them is not automatic. The law allows cases to remain local, even when patterns suggest they should escalate. Here, segmentation prevented consolidation. Complaints that might have formed a systemic picture were handled as discrete events, each legally complete on its own, none demanding structural review. Then there is confidentiality. Certain agreements and filings can be sealed or restricted under law. This does not erase records. It limits their circulation. Information remains accessible to institutions while remaining invisible to the public. The result is a dual reality: transparency within the system, opacity outside it. Importantly, none of these tools are illegal. They are foundational. What distinguishes this case is how consistently they were applied in the same direction, reducing exposure, limiting escalation, and finalizing outcomes before broader accountability could take shape. Jeffrey Epstein benefited from this structure not because the law was broken, but because it was used efficiently. The process did not shield him through secrecy or exceptional measures. It shielded him through routine ones. This is why later disclosures feel jarring. They collide with a legal reality that had already been settled. The documents do not contradict the outcome. They reveal how the outcome was engineered. The law, in this case, functioned less as an instrument of exposure and more as a mechanism of containment. It allowed facts to be acknowledged without being fully confronted, harm to be recorded without being fully addressed. Understanding how this happened reframes the entire case. It shows that the most effective form of protection is not concealment, but procedure, not denial, but resolution, not silence, but paperwork. The crime did not survive despite the law. It survived through it. Public attention tends to treat this case as if it moves in a single arc: crime, investigation, trial, outcome, scandal. The reality is a sequence of closures and reopenings, not always of the case itself, but of the record. That difference matters. A case can be over in a procedural sense while the truth remains distributed across filings, testimony, and sealed materials. What changes the public's relationship to the story is not always a new event. It's a change in what the system allows to be seen. This is where when becomes crucial. The moment the records begin to surface is not the moment the wrongdoing begins, and not even the moment the institutions first respond. It is the moment the documentation stops functioning as an internal artifact and becomes something external actors, journalists, researchers, the public, can actually examine. In many legal proceedings, records are restricted for reasons that can be legitimate: privacy, ongoing investigations, procedural protections, negotiated confidentiality. But restrictions also produce a predictable effect. They reduce outside scrutiny, and they delay the moment when inconsistencies become visible as a pattern rather than isolated fragments. In this case, the release of records happens not through rumor or discovery, but through formal legal mechanisms: court motions, judicial review, and decisions to unseal or disclose materials generated during litigation. That is the key point for this channel's framing. The documents are not found, they are authorized to exist publicly. This reframes the narrative away from spectacle and towards structure. When documents are unsealed, the public often interprets this as the system finally telling the truth, but unsealing is not confession. It is a procedural change in access. The system is not admitting wrongdoing, it is changing the boundary of visibility. And boundaries are political in the deepest sense. They define what can be discussed responsibly, what can be investigated, what can be confirmed, what can be denied. Jeffrey Epstein remains constant across these stages. The shifting variable is not his identity, but the visibility of the record surrounding him. For years, the most consequential decisions are made, while the public record is limited, fragmented, or inaccessible. When visibility increases later, it feels like a turning point, yet many outcomes are already locked in place. This is the central tragedy of delayed disclosure. It creates the appearance of progress after the window for accountability has narrowed. The surfacing of records is therefore not a climax, it is an aftershock. It confirms what the system previously absorbed. It reveals what procedure previously contained. It allows observers to connect dots that were always present but kept apart, not necessarily by a single deliberate act, but by the ordinary operation of legal barriers, institutional habits, and time. So when the records surface becomes part of the story itself. Because in a functioning accountability model, documentation triggers action. Here, documentation triggered containment, and only later, visibility. And by the time visibility arrives, the case has already taught its final lesson. A system can allow truth to exist, and still delay it until consequence is no longer possible. As public attention returns to this case through the release of documents, confusion follows almost immediately. Headlines collapse categories. Social media compresses legal language into implication. Names are treated as conclusions. This block exists to stop that slide. The documents that resurfaced are not revelations in the investigative sense. They are judicial records, materials generated as part of legal proceedings and later made public through formal court decisions. They were not leaked by anonymous sources. They were unsealed. That distinction matters. Unsealed documents are records that already existed within the system. Their release does not certify their contents as findings of fact. It simply changes their accessibility. The law treats documentation and proof as separate things, and these records sit firmly on the documentation side. What do these documents contain? They include filings, depositions, motions, and references made during civil litigation. Much of the material reflects what parties said, not what courts established. Allegations appear alongside denials. Testimony appears without verdict. Context is partial by design. A document can record that a name was mentioned without asserting that the name belongs in a criminal case. A document can preserve an accusation without validating it. A document can exist without assigning responsibility. This is how legal records function. The danger emerges when documentation is mistaken for adjudication. The presence of a name in a filing does not equal involvement. Inclusion does not imply guilt. Courts distinguish carefully between what is entered into the record and what is proven within it. That distinction has been repeatedly ignored in public reactions. Jeffrey Epstein appears throughout these materials not because the documents expand his case, but because they preserve its procedural footprint. They show how the case was discussed, referenced, and constrained, not newly discovered conduct. In other words, the documents tell us how the system talked to itself. They reveal the boundaries of what was litigated, what was excluded, and what was left unresolved. They show how much information existed at various stages, and how little of it entered formal judgment. Crucially, they also show what the documents do not do. They do not assign criminal liability. They do not reopen closed cases. They do not replace trials that never happened. Their value lies elsewhere. They allow us to map the gap between record and consequence, between acknowledgement and action, between what the system knew and what it chose to confront. When treated responsibly, these documents do not explode the case, they stabilize it. They confirm that the problem was never a lack of information, but the way information was processed. Understanding what these documents actually are protects the analysis from distortion. It prevents the case from being hijacked by speculation. And it reinforces the central claim of this video. The shock is not that documents exist. The shock is that they existed for so long without changing the outcome. The documents don't accuse. They don't reveal secrets. They don't finish the story. They show, with bureaucratic clarity, how a crime can be fully recorded and still remain structurally unresolved. Transparency is often treated as a cure. Release the documents, open the records, let the public see, and accountability will follow. This case shows the limits of that belief. When transparency arrives after a procedure has already closed, it does not correct the outcome, it only reframes it. The legal decisions that shaped this case were finalized long before public access existed. By the time the records were unsealed, the system had already moved on. This is why the timing matters more than the content. The documents do not expose an active failure, they document a completed one. They appear in a space where legal remedies are no longer available, and institutional responsibility has already diffused. Transparency in this context becomes retrospective, informative, but not corrective. What remains is public reaction without procedural leverage. The case did not end because the truth was unclear. It ended because the system reached a state of formal resolution. Once that threshold is crossed, later disclosure cannot reopen what procedure has already sealed. This creates a structural imbalance. The public encounters the case at its most visible moment, while the system encountered it at its most decisive one years earlier, behind closed filings and negotiated outcomes. By the time transparency arrives, accountability has been converted into archive. This is not an anomaly, it is a pattern. Institutions are designed to act early and explain later. When explanation comes after action, it serves a different function. It reassures process rather than challenges it. It signals openness without restoring consequence. In this sense, delayed transparency can even stabilize institutional legitimacy. It allows systems to appear responsive without revisiting foundational decisions. The story becomes about access, not accountability. And that is the final lesson of this case. The problem is not that documents were hidden. It is that they were released after they could no longer matter. When transparency comes too late, it does not prevent harm, it records it. It transforms active failure into historical knowledge and unresolved accountability into public memory. This is why the case endures. Not because it remains unsolved, but because it was resolved too efficiently before scrutiny could change anything. The documents close nothing. They simply arrive at the moment when closure is no longer possible. And in that gap, between knowing and acting, the system reveals its most enduring protection: time.